Hello, welcome to Listen and Score. So, this channel is meant to help you score more marks, and here we are for you to read for you. Right, and this is from first semester, the contract paper, unit 1. So, we are going to go with the concept which can be taken as an answer to the question, like define contract and mention the essentials of a valid contract and the related questions. So here we go with that. Meaning. The word contract is derived from the Latin contractum, which gives meaning drawn together. Thus, the meaning of contract is a drawing other of two or more minds to form a common intention, giving rise to an agreement. Definition according to Blackstone. A contract is an agreement upon a sufficient consideration to do or not to do a particular thing. According to Anson, the law of contract is that branch of law which determines the circumstances in which a promise shall be legally binding on the person making it. According to Pollock, the law of contract may be described as the endeavor of public authority, a more or less imperfect one by the nature of the case, to establish a positive sanction for the expectation of good faith which has grown up in the mutual dealings of mean of average right-mindedness. According to Halsbury's Laws of England, a contract is an agreement made between two or more persons which is intended to be enforceable at law and is constituted by the acceptance by one party of an offer made to him by the other party to do or to abstain from doing some act. Now, as per Indian Contract Act 1872, Section 2H, an agreement enforceable by law is a contract. Formation of contract. A contract means an agreement which is enforceable by law. An agreement consists of reciprocal promises between the two parties. Each party is legally bound by the promise made by him. The law requires the parties to make their own contract. It will not make a contract for them. The terms of the contracts are identified are illusory. The parties to a contract in a sense make the law for themselves. In simple way, we can say offer plus acceptance is equal to agreement. However, the agreement concluded between the parties must be enforceable by law. The contract or an obligation to perform a promise could arise in following ways. Number 1, by agreement and contract. Number 2, by standard form contract. Number 3, promissory estoppel. Let us see the first one. Agreement and contract. It is the most common method of making a contract through an agreement. This follows offer plus acceptance is equal to agreement. Section 2H of the Indian Contract Act 1872 defines it should be enforceable by law, and Section 2E defines agreement. Every promise and every set of promises forming the consideration for each other is an agreement. Let us take an illustration. A promise to deliver his house to B, and in return B promises to pay a sum of rupees 50,000 to A. It is said to be an agreement between A and B. So, all agreements enforceable by law are contracts and valid. But all agreements are not enforceable by law, and therefore all agreements are not contracts. Example, an agreement to sell a scooter is a contract. An agreement to come to dine is a mere agreement. It cannot be enforceable by law. Thus, all contracts are agreements, but all agreements are not contracts. Let us see the second one. Standard form contracts. Due to speedy development of modern technology, the man's life has been changed rapidly in 19th and 20th centuries. Aeroplanes, trains, motor vehicles, postal services, banking, insurance, etc. are the examples. There are hundreds, thousands, lakhs of persons utilizing these services. For the better service, it is not possible to have the principle of agreement and contracts. The services of public utility have their own contracts, pre-drafted matters prepared by one party, accepted by other party, that is the consumer. These contracts are called standard form contracts. Problem: Begum travelled from Dubai to Delhi by Air India. She was informed that her luggage was lost. In that luggage, there is gold worth rupees 2 lakhs. She claimed that amount from Air India. Air India argues that their liability is rupees 10,000 only, as stated in the ticket issued to her. Solution: Begum could get only rupees 10,000 as per the terms and conditions pointed on the ticket. In Parker's case, this principle is decided. In standard form of contracts, it is the first duty of the offerer to give adequate notice to the offeree of the printed terms and conditions. And also, it is the duty of the offeree to see the terms and conditions printed or painted. Third one, promissory estoppel. Sometimes there may be no agreement and no contract in strict sense of the term, but a person making a promise may become bound by the doctrine of promissory estoppel. So let's see this. Hughes versus Metropolitan Railway Company, 1877. Brief facts. The landlord gave a notice to the tenant to repair the premises within 6 months, failing which the lease was to be forfeited. 1 month after the notice, the landlord had negotiations with the tenant to sell the leased premises. Negotiations took more than 3 months' time. However, they were failed on price. Meanwhile, the stipulated time of 6 months in the notice was passed and no repairs were carried by tenant during that period. After 6 months, the landlord asked the tenant to vacate the premises. The tenant contended that the period of 6 months would commence from the date of failure of negotiations of sale. The court admitted the argument of the tenant and held that the negotiations on the part of landlord was a promissory estoppel. His conduct was an implied promise to suspend the notice, and the tenant acted on it by not carrying out the repairs. The essential ingredients of a valid contract. The contract between the two parties is a form of self-regulated one. The law does not interfere each and every contract. The parties have the freedom to form a contract for themselves by fixing the terms and conditions binding on themselves. The parties may create rights and duties for themselves. The law requires the parties to make their own contract. It leaves men's affairs to self regulation achieved by agreement of parties. But that freedom should not be misutilized. Hence, the law imposes certain restrictions for the benefit of the whole society. The valid contract must contain the following essentials. Number 1, free consent. 2 or more persons are said to consent when they agree upon the same thing in the same sense. Consent is said to be free when it is not caused by coercion, undue influence, fraud, misrepresentation, mistake. Sections 13 to 22 of the Contract Act explain the free consent. Competency of the parties is number 2. Every person is competent to contract who is of the age of majority according to the law to which he is subject, and who is of sound mind and is not disqualified from contracting by any law to which he is subject. Sections 11 and 12 explain the competency of the parties. Third one, lawful consideration and objects. The consideration or object of an agreement must be lawful. An agreement without lawful consideration and object is void. Sections 3 to 25 explain about the lawful consideration and objects. Number 4, void contracts. The fourth essential ingredient of a valid contract is that the agreement should not be expressly declared to be void by the Contract Act. Sections 24 to 30 explain that certain agreements are void. Agreement in restraint of marriage, agreements in restraint of trade, agreements in restraint of legal proceedings, agreements of uncertainty, agreements by way of wager are void. Fifth one, writing. The proviso of the section 10 of the Contract Act provides that wherever the provisions of any other law requires the agreement must be in writing. For example, sale deed, mortgage deed, etc. Unilateral and bilateral contracts. As a general rule, every contract must be concluded between two persons or between two parties. It is called bilateral contract. Examples: mortgage deed, lease deed, sale deed, etc. A contract in which only one party is bound to a performance is said to be unilateral contract. The bilateral contracts are common, whereas unilateral contracts are rare. Let us see this. In Sri Mahadioji versus Baldio Prasad, 1943 Audh 89 case, the defendant agreed to transfer certain property to the plaintiff if the plaintiff performed certain personal services. Plaintiff performed the services. The defendant did not transfer the promised property. The plaintiff brought specific performance. The defendant argued that the contract lacked mutuality. The court negatived the defendant's argument and held, as to the question of reciprocity, it is true that if the plaintiff had, in spite of the agreement, failed to do services, the defendant could not have compelled him to do it. But the argument from this that if the plaintiff did the services, he could not compel the defendant to perform his part of the contract is not sound. In India, in marriages, particularly of daughters, the father promises to give certain land to her daughter for her livelihood. It is held valid. And this is all in this session. Thank you for listening. And if you have not yet subscribed, please subscribe and share with your friends.